Hello friends, in this particular episode, we will see what is mediation, the journey of mediation in India, the prospects of mediation in India. And for this, I have with me Advocate Parimal Shah sir, who is in practice since last 43 years. Sir is practicing in practically all courts of Bombay, maybe city civil court, high court, small causes court, every court. The journey of this mediation started for Sir somewhere in 2001 when Bombay City Civil and Sessions Court did a workshop as regards mediation. Subsequently, in 2004, Sir did a postgraduate certificate course in ADR from Bombay University. Subsequently, in 2006, the mediation work started, but the full-fledged work of mediation in all courts started in 2010, where Sir became the panel member in City Civil Court, High Court, Small Causes Courts. Subsequently, Sir has also attended training programs conducted by Indian Institute of Corporate Affairs. Further, training program conducted by Indian Merchant Chambers. Further, there is a now at present a proper training program for mediation done by the Bar Council of Maharashtra and Goa in association with the Mediation and Conciliation Project Committee of Supreme Court of India. At the same time, Sir is also the Honorable Secretary of the Association of Mediation Practitioners. So, we will understand from Sir this entire concept of mediation. Sir, first of all, thank you very much for giving your time for this purpose. Now, I would like to request you to commence with the program.
Okay. Thank you. Thank you for giving me opportunity to share the introduction of subject of mediation. I am happy. It's a subject I hold close to my heart, and I will endeavor to introduce the subject in the best possible manner. Anyway, friends, so I'll begin with what is mediation. Mediation, a very simple definition of mediation can be said to be a professionally assisted negotiation between two parties having dispute or maybe difference of opinion. The difference here is that the new person, the mediator, is a trained and qualified person, and he also brings to the table the domain knowledge of the dispute as such, and basically he remains neutral, independent, and assists the parties in negotiation. Because of the techniques of communication that the mediator brings to the table, he or she ensures that the discussion between both the parties takes place in a right atmosphere, right direction, and by and large it is believed that basically the mediator or the process of mediation re-establishes the communication channels between two parties. So that is the purpose of mediation, to let both the parties communicate. Because through research it was found that when two parties have strong difference of opinion or dispute, then either the communication channels between both the parties have either broken down, collapsed, or they have got corroded, and therefore both the parties on their own cannot communicate with each other, and unless there is communication, no solution can emerge. So it's a informal but structured process to bring about negotiation between both the parties. Now, it is something different from our existing court system. Our court system is known as adversarial system, because in the court system, each party looks at the other party as an adversary, and so there is a spirit of fighting with that party. While in mediation, that is not so. In mediation, both the parties are supposed to communicate with each other, they are supposed to negotiate and try to find a solution which is acceptable to both of them, which they feel that which is good for each of them. So that's why this is known as one of the methods of alternate dispute resolution system. And as an alternate to the adversarial system, it is utilized as alternate dispute resolution system. The other, and so in abbreviation, it is called ADR. But in adversarial court system, you can't get the results which this you can get, which you can get in mediation. Mediation is a informal, flexible process. So, a mediator is not bound by the Indian Evidence Act or Civil Procedure Code, and therefore the canvas in front of the mediator and the parties in mediation is much larger than the canvas in front of the court. So that's why the solutions that can emerge in mediation are generally supposed to be better for the parties, and in court system there can't be a win-win situation. In court system, either one party who has won will be happy or the other party who has lost will not be happy, and there can't be a win-win situation for both the parties. But in mediation they can come up with a solution with which both the parties can be happy, and that's why it is thought or it is taken that in mediation parties can come up with win-win situation, and when there is a win-win situation both parties can be happy with it, and therefore it is also known as appropriate dispute resolution system, and so ADR is also interpreted as appropriate dispute resolution system. Now, it's an informal but structured process. That is what mediation is all about. And people feel that general impression is that in mediation parties just talk. It is a very simple process, but it's not so. It is a very powerful process. It is a very powerful process. It has been designed after a very in-depth legal and psychological research, and therefore it should not be taken lightly. Okay. Now I'll just deal with basic features of mediation. Mediation has certain ingredients. Firstly, it is voluntary, it is confidential, it is transparent, and it is also informal. Okay. So voluntary means that both the parties have to agree to go for mediation by consent. Unless both the parties voluntarily agree to go for mediation, mediation cannot take place. So both the parties must agree to it. But generally what happens that most of the times parties may not understand, particularly in India right now the awareness about the concept is not that high, and therefore the parties may have to be prodded to go for mediation, which is being done by courts or their advocates. They explain to them the benefits, and therefore the parties, and also many times courts recommend parties to go for mediation, because at the end of the day in mediation there is nothing adverse that happens for the parties. The parties don't stand to lose anything. They have to just spend some time in mediation. That time is lost, say, but that is a very limited time of 2-3 years, 2-3 months or 4 months. So parties don't stand to lose anything, and it's a comparatively inexpensive process. And also, once they try it, they will come to know what is the strength of mediation, and therefore courts generally promote it. And when parties understand these things, they agree to go for mediation, and once they go for mediation, when they realize that it is beneficial to them, they embrace it or they participate voluntarily. So far as confidentiality is concerned, then whatever is discussed in the course of mediation is not disclosed to anybody, and particularly to the court or any outside world. It remains within two parties, their counsels and the mediator. And of course, parties, they can discuss it with their think tank, they can discuss it with their advisors or those whoever are helping them in the process for taking decisions. They can discuss it with them, but otherwise it is not disclosed to anybody else. And so, for example, in court annexed mediation, the report of the mediator to the court will not disclose as to what was the discussion in the process of mediation. No part of the mediation process will be disclosed to the court. If suppose the mediator matter is settled, case is settled in mediation, then the report of the mediator to the court will only mention that parties have settled the matter through mediation, and a duly signed agreement by the parties is annexed herewith for passing further orders. So that is how it will be done. If it is a private mediation, the parties will enter into an agreement which is known as Mediation Settlement Agreement or MSA, and that they can enforce it whenever the need arises. And so far as parties not reaching any agreement, because it is the option of the parties, only when parties are convinced that it is a good deal for them, they can take it. Otherwise, the parties can agree to disagree. So in that case, the mediator only reports to the court that despite all efforts, no agreement could be reached between the parties. It is known as mediation failure report in court terms. But in my personal opinion, mediation never fails. It is not a waste of time or resources. It is always an investment. I have come across many matters in which at that particular time parties don't reach an agreement in mediation, but somewhere down the line after 6 months or a year they work it out, and so the seeds are sown at the time of first mediation, and at that time maybe it is not the right time, and so the appointed day comes afterwards, and so it works. So mediation never fails. It is never useless. Okay, but as I said, mediation is a very sort of powerful and strong process, and it does give results. Okay. Also, you see, parties may not be willing to go for mediation, but when the suggestion comes from the court, then generally they don't turn it down, because basically they feel that if the judges are recommending to go for mediation, there must be something good about it, and anyway let us try it, or they don't want to offend the judge or the court, and even their advocates sometimes tell them that okay, since the suggestion is coming from the court, you accept it, and it will be good and in your interest, and therefore also the parties agree to go for mediation. So that is how the consent may also be taken. But otherwise it's a confidential process, nothing is disclosed to anybody, parties don't stand to lose anything, and even afterwards, suppose by chance the matter is not settled between the parties and eventually they have to end up in court, or the court annexed mediation the matter goes back to court, then at that time also the parties on their own also cannot refer to any part of the discussion that took place in the process of mediation, in the course of mediation. And in fact, if any party attempts to disclose or use it in the process of their court matter, then the court will frown upon such an attempt, because anything that is discussed in the course of mediation has to be confidential as per the rules framed for it, and therefore it is not allowed to be used. And also, as per the rules governing mediation, the mediator cannot be called as a witness in the court, except for any criminal offense that took place in the course of mediation.
Okay.
So otherwise the mediator cannot be called as a witness. That is an immunity granted to mediator, and also that provision is meant to safeguard the confidentiality of the mediation process. So nobody can use that also as a tool to find out as to what happened in mediation. So far as transparency is concerned, whatever happens in front of parties, and they themselves discuss it along with their advocates if they want to have their support. So everything is transparent, whatever discussion takes place, and also mediator is a neutral person, he is an independent person, he has nothing to do with either of the parties, and therefore everything is transparent. Okay, so basically the fourth component is, now what is the procedure in mediation? So mediation, as opposed to the court hearing of the matter or the arbitration, the mediator doesn't have to judge. He doesn't have to judge the matter. He doesn't have to decide as to who is right, who is wrong. He has to just help parties to negotiate and ensure that the negotiation takes place in the right direction, and it is in the direction of finding a solution to the problem of parties. So therefore it is not something where the mediator has to hear a case and give judgment. So in mediation the process is that actually, and it's an informal, flexible process. The mediator is not bound to follow a particular process or particular steps, but broadly there are certain standard standard steps that are followed by a mediator, and these 4 steps are introduction, then joint session and private session, also known as caucus, and agreement. So in introduction session, the mediator introduces himself, he gets the introduction of parties, then also invites parties to introduce the facts of the matter briefly, and so comes on same page, tries to come on the same page with the brief facts of the case. And once that is done, then thereafter the mediator has a joint discussion with the parties and tries to go deeper into the dispute as or facts of the dispute. Once that is done, and thereafter he can talk to both the sides separately, because you see each side may have something to say which they may not be wanting to say or they may not be able to say in front of the other side. And the mediator has to find out as to what is at the root of the dispute. And therefore, the mediator has to talk both the sides separately also, and sometimes if it is talked in front of the other side, then the party may have to disclose certain facts which are likely to be used by the other side in the for future litigation if the matter doesn't get settled in mediation. So one has to guard the likely evidence that the party may have to use in future, and therefore also some parties may want to discuss out those things with the mediator in private session rather than joint session. So therefore a private session, which is also known as caucus meeting, is required to be held between the mediator and the party. And once after that the bargaining takes place, each side tries to convince the other side that this is required to be done, this is appropriate, this is very fair, just and fair. And after having finished all those bargaining, parties come to some, they reach some equilibrium point where they agree that okay, just to close the matter, let us agree to this formula and we can work it out. So then there is the stage of preparing an agreement. And they enter into that agreement. It is duly signed by them, by the councils. If it is court annexed mediation and it is filed in the court, known as consent terms, or when the court passes a decree. As I said, if it's a private mediation, then they only enter into an agreement, and that agreement can be enforced like any other agreement. Okay, so these are 4 standard steps that can be taken by the mediator. But as I said, we must remember that it's a informal, flexible process. A mediator is not bound to follow all these 4 steps in all cases. In fact, in some cases we find that there is a very low compatibility between the parties. They can't see eye to eye with each other. They can't sit together with each other, and if they sit together, there is a high likelihood of a fight getting started between the parties. And when the mediator observes this, the mediator avoids that joint session and talks to both the sides separately, and after establishing some rapport between the parties, after they have vented out that lava in them, thereafter he calls a joint session. So these are some standard steps, but not necessarily that they should be mandatorily followed. Okay, so this is how the procedure in mediation works. And people also feel, general impression is that mediation is something simple, talking it out, as they say, as I said. So, some people say, okay, let us go for mediation. Let us see what the other side says, what mediator says. Even, the professionals, learned professionals also, who are not so much aware about the process of mediation, they also tell their clients, okay, go see what mediator says. If you feel something beneficial for yourself, just agree to it. Otherwise, say no, and the process will end. And some people also take it very lightly. They say, अरे mediation में क्या होने वाला है? इतना try किया, पहले किया, अब हम लोग सब कोशिश कर चुके हैं, अभी क्या होगा? Mediation में अभी क्या होगा? So that is not so. Because see, whatever efforts that parties make prior to coming to the court or otherwise, they are not scientific mediation efforts. There is no scientific or systematic mediation that has taken place. Generally, one of the ingredients is missing. Now, for example, all those efforts that take place, the mediator may not be neutral, may be representing one party or the other. Even advocates negotiate for their parties. But at that time also, it is negotiation with the help of advocates. And when there is a dispute, there is a high degree of distrust between parties. So whatever good suggestions also come, the other side will look at it doubtfully. That no, see, there must be something, there must be a catch. It must be, in their interest, and that's why they are proposing this. So that's why when it is done with the help of a neutral mediator, and parties get a chance to even speak to mediator separately, and they can assess as to what the mediator is saying, whether it is in their interest or not. They can, cross-check that whether it is really going to benefit them or not, and then only it can work. And it looks like a simple process, but it is not simple. It is a very skilled process, and also it is a very highly skilled negotiation, and therefore parties should take it very seriously, and their advisors and advocates also should take it very seriously. Now we will come to developments of mediation internationally. So internationally, since about early 1900s, say in 1910 or so, it means USA is the forerunner in mediation. So far as mediation is concerned, the USA is forerunner in mediation. As early as 1910 or so, there was a lot of dissatisfaction with the court adversarial system in US, and therefore there was a lot of criticism. So since then it was there brewing, but in 1970s, early 1970s, the again that simmer of discontent and criticism for the adversarial system came to the fore, and thereafter they started examining that let us innovate the system, let us try to find out if there is something that we can do about it. And from that thought, the research took place, and since 1990s, say middle of 1990s, they introduced mediation, and it has been one of the preferred tools of ADR in USA by now. And thereafter, after it was adopted in USA, thereafter Europe, Australia, UK, Argentina, Brazil, all other countries also took it. And actually the international forum was also trying, means promoting conciliation. For example, United Nations Commission on International Trade, which is known as UN Citral, it formed rules for conciliation in 1980, but it was promoted as conciliation. Even International Chamber of Commerce, that also introduced it as conciliation, and it was promoted as conciliation. But thereafter, as the concept evolved, they came up with the concept of mediation. Now, there is actually a very thin line between conciliation and mediation. The only difference sometimes is, actually both the terms are synonymous, but the only difference that can be taken is that conciliation, conciliator can give suggestions regarding settlement proposals, that okay, you can settle the matter like this on these terms. But so far as mediation is concerned, a mediator cannot give any proposal for settlement. Mediator has to drive both the parties in the right direction and help them to come up with a formula which is acceptable to both of them. So that is the minor difference. Otherwise, in conciliation also, the person who acts as conciliator is a neutral person. The process is confidential, and everything works almost like mediation.
Okay.
But in mediation, generally, it is the parties who decide. So that is how the developments took place, and those rules which were formed by United Nations UNCITRAL Commission. So then thereafter the concept evolved, and now, as I said, most of the countries of the world have embraced it, and it is working as a first try method, that okay, if there is a dispute, let us try out mediation, and that is how it has evolved. Now, as I said, I just explained to you the difference between mediation and conciliation, but what is the difference between mediation and arbitration? That also needs to be understood. In arbitration, a person acts as an arbitrator, but he acts as a judge in a way. Parties present their case to the arbitrator, and arbitrator gives his judgment that okay, this is what is right and this is wrong, this party is right, this party is wrong, and that is known as award, the arbitral award, which is legally enforceable. So there is a award that takes place. In mediation, mediator doesn't give any award, mediator doesn't give any judgment. Mediator only helps parties to arrive at a settlement or arrive at a decision that they can't agree to any settlement. That's all. Mediator doesn't give any award or judgment, and that is the difference. But an arbitration is a sort of mini trial, mini court trial, and it only saves time, it works faster than the court system. That is the only difference, but otherwise the arbitrator acts like a judge. So that is the difference between arbitration and mediation. Now, so far as mediation in India, history of mediation in India is concerned, quite a few people say that the concept of mediation is very old in India. For centuries, we in India there is a culture of settlement. People always resolve their disputes. They don't fight it out. Also, some people say that the earliest mediation took place in the time of Kauravas and Pandavas. Krishna acted as a mediator between Kauravas and Pandavas. So the concept of mediation, even the panchayats used to mediate, and therefore the concept of mediation is very old in India. But you see, that right from the Mahabharata time and up to panchayat, all those things which used to happen had some elements of mediation, but they were not exactly mediations. Because as I said, the mediation requires a neutral person, a trained person, a person who is trained as mediator, who knows to bring the communication techniques to bring about appropriate communication between the parties, and also that parties should be able to decide, and the participation should be voluntary. So in all these processes that were followed earlier in India, some of the element was there, but some other elements were missing. So they were not exactly mediations. But yes, India has always tried to follow the path of conciliation, and therefore we can say that the culture of conciliation is not new to India, but mediation in a systematic and structured way is of recent origin in India. In our legal system, the sort of again the mediation was introduced as a conciliation. In Industrial Disputes Act, conciliation provision was there. There were provisions for conciliator, and the conciliator tried to bring about a conciliation between workers and the employer. Thereafter, we had Arbitration and Conciliation Act 1996. In that act also, there is a chapter on conciliation. So conciliation was introduced through that also. But the structured mediation was introduced in India through Section 89 that was amended in Civil Procedure Code 1908 with effect from, it came into effect in 2002, and since then there was a provision for referring the matters to mediation. And also in Order 10 also there is provision, Order 10 of CPC, there is a provision that before the first hearing the court should examine and ask the parties to refer to one of the methods of conciliation, alternate dispute resolution systems as provided in Section 89. That was there. But that, despite that provision, it was not utilized to a great extent. And really, the push was not there. The effective push was not there to utilize that provision. But in about 2005, in fact, 2005, the Supreme Court of India formed a Mediation and Conciliation Project Committee, which is also known as MCPC. And MCPC formed a committee to draft model rules to govern alternate dispute resolution systems. And that those rules were formed by that committee, and all the high courts in India adopted them with some modification or without any modification. But all those rules were adopted, so the working rules for procedural aspects of mediation were also in place. And in 2005, that committee was also took up the function of even training advocates and judges in imparting training in mediation. And thereafter, they also formed, MCPC also formed committees under it, right from High Court till Taluka level. The mediation monitoring committees were formed, and therefore the mediation activity got impetus. And of course, there were certain cases, 3 cases, that also highlighted the procedural need of the mediation, and section 89 was in focus. One of the cases is the Salem Bar Association versus Union of India. Then there was Salem Bar Association 2 versus Union of India, and the third case is Afcons Infrastructure Limited. That matter was also one of the most important matters, which also highlighted the need for alternate dispute resolution systems. So, with these 3 cases also contributing to ADR processes, the mediation concept got a push. And thereafter, the various law commissions also recommended and promoted the concept. And then, because of this, putting in place of MCPC, the various mediation monitoring committees, all the courts in India, right from High Court till Taluka level, in fact from Supreme Court to Taluka level, had established mediation centers by 2010. And since 2010, all the courts have been referring matters to mediation, and the mediation culture has spread in India. And in 2018, the an amendment was brought about in the Commercial Courts Act 2015, whereby Section 12A was introduced, and that introduced the concept of pre-institution mediation. And under that provision, any commercial dispute, if a suit is filed for any commercial dispute having value of 3 lakhs or more, then it has first mandatorily go to mediation. Only after parties have tried mediation, and only after either the mediation has failed, or then only the suit is taken on file of the court, and then it proceeds further. According to me, this is a revolutionary step, very revolutionary step, and it is like, nipping the problem in bud. So, but yes, in that there is one exception, that if in that matter or whatever commercial matter is there, if some urgent interim reliefs are required, then the matter can be put up before the court for interim reliefs, because a mediator doesn't have a power to pass any orders, leave aside the urgent orders. So only if urgent interim orders are required, then the matter is directly put before the court. Otherwise, they are directed to first take the route of mediation, and only after the failure of mediation, the matter proceeds further in the court. So that is one of the developments, important developments that has taken place in India, and this is how it has proceeded in India. Now we can look at types of mediation. The mediation can be either private mediation or court annexed mediation or statutory mediation, which you can say is pre-institution mediation. So far as private mediation is concerned, it is like both the parties agreeing to submit their dispute to mediation by consent. Means once they come to know that there is a dispute, then they may decide that, okay, let us take the matter to this particular mediator, and let us undergo mediation. So that is private mediation, without intervention of court or any proceedings in court. So in some cases, say, parties have already gone to court, and thereafter the court refers the matter for mediation. With the intervention of the court, if the matter is referred for mediation, it is known as court annexed mediation. So that, there is a case, there is a litigation, and in the course of litigation, when parties go for mediation, it is known as court annexed mediation. And pre-institution mediation is before filing a suit, or before taking any legal proceedings, parties are either required by law to go for mediation, or they themselves choose to go for mediation. That is pre-institution mediation. So these are three types of mediation that take place. Now, private mediation is not governed by any law, but generally mediators can follow the basic principles of internationally accepted basic principles of mediation, and they may also otherwise follow the mediation standards that are prescribed under various Indian laws and rules. As I said, this the model rules that were drafted by MCPC referred committee and accepted by most of the high courts. They are known as civil procedure, ADR and mediation rules. In Maharashtra, it is the Bombay High Court which has, with some amendments, accepted those civil procedure, ADR, mediation rules 2006. So those are enacted. So basically, that is what happens. Now, we may also look into what types of disputes are better to be referred in mediation. So, in a way, any dispute, any and every dispute can benefit through mediation. At least they can benefit to a limited extent, or it is only a question of degree according to me. But any dispute can benefit through mediation. But generally it is felt that disputes involving relationships between the parties, say when parties are in relationship, husband and wife, or employer-employee, or supplier and the purchaser. So, you know, business is partners in a business. So when parties are into some relation, some sort of relationship, some form of relationship, it is believed that those disputes are better for more suited for mediation, because one of the major advantages of mediation is that mediation can save the relationships between the parties. While when they go to court, they fight like adversaries, and that hurts the relationship, and sometimes it destroys relationships. It ends up into enmity, and therefore such matters are more suited. Generally, it is believed that only family matters, family court matters, or family disputes are suitable for mediation, but that is not so. In fact, commercial matters are also very much suited. But you see, people have a misconception, I would say, that only family matters can be referred to mediation, but that's not so. Yes, they are also suitable, but other matters also where parties want to maintain confidentiality, where parties don't want to disclose facts. Of course, in family matters, parties don't want people to know the world, they don't want the world to know what is their personal problem, but there are other matters also. In commercial matters, for example, a corporation may not want to disclose the facts about its patent, I mean the process of its patent to be disclosed in court, and therefore they may prefer mediation. There can be a corporation who doesn't want the world at large to know a suit filed for deficiency of service by one of the customers, that such a litigation they had to face. Also, when they settle such disputes, they don't want people to know as to what amount is paid by way of compensation to work out that dispute.
Correct.
So there are certain matters where parties may not want to disclose all these facts to the world, and so wherever confidentiality has to be maintained, those matters are very much suitable. And also where parties can see that, or if the dispute doesn't involve complexities of legal interpretation or legalities, then those matters are also very much suitable for mediation.
Correct.
But there are certain matters which can't be referred to mediation. Those type of matters are that suppose if a right has to be decided and declared by a competent court. For example, if a tenancy has to be declared, so that can be done by a tenancy court. A matter involving interpretation of a law or a matter involving interpretation of provisions of Constitution of India, that can't be decided in mediation.
Correct.
Also, there might be a matter in which the judgment may be such that it may be applicable to all other people also. A ratio is going to act as applicable to all other people. That matter cannot be decided in mediation. So, and also non-compoundable offences, criminal offences, where the criminal offence is compoundable, that can certainly be referred to mediation and can be worked out through mediation, because otherwise also anyways parties can compound the offence by personal discussion. So that can be done, but when it's a non-compoundable offence, then it can't be referred to mediation. Or if it is referred, it can benefit in a limited way, and thereafter they may have to follow the procedure of the court. So that is how it works. Now, question is that how can one get compliance to whatever is agreed in mediation? Suppose if parties come to an agreement in mediation, there is an MSA in place. So how can one get compliance? So because parties are really looking at that, and that is very important, because otherwise the process has no meaning. They invest so much time, and then thereafter they come to know that the other side is not complying with the agreement, and they have no option but to again go to court. Then that's not good. So compliance is very important. So as we had discussed earlier, the compliance can be also looked at the mediations from the types of mediation. See, in private mediation, the parties reach an agreement, and if one wants to seek compliance with the agreement, then the only option for the party is to go back to court and seek compliance on that agreement. It will be like a suit for compliance of agreement. But if suppose it was a court annexed mediation, then parties have filed that agreement in the court, and the court passes a decree in terms of that agreement. So that compliance can be through court as a decree. So that is a decree itself. And also in cross-border mediations, where again the agreement is reached, and that agreement itself has to provide the procedure for compliance, that what will be the law by which the agreement will be governed, what will happen if one party breaches or rather does not comply with the terms of the agreement, then which is the jurisdiction where parties can seek compliance, etc. So all those things can be provided. And that's why the compliance is an issue in international mediations, and therefore the international mediations right now are at a low level, because parties are apprehensive about getting compliance in different jurisdictions. And but so far as the other mediations are concerned, particularly court annexed mediations, the compliance can be very easily got as a decree, because in that case the mediation agreement itself is converted into a decree, and so it has the same value as a decree obtained after contest. So that compliance is very easy, and that may be one of the reasons that right now the court annexed mediations are more in numbers. Okay, so that is how the compliance has to be taken. But actually the United Nations, this UNCITRAL, has come up with a convention for international mediations, and that has been that convention has been signed in last August 2019 by many countries, and that convention is providing for standardization of mediation process as well as compliance with the mediated settlement agreements in commercial matters, reached in commercial matters. That convention is signed by quite a few countries including India, but all the countries have to ratify it and put in place the law to implement the terms of that convention. And this convention was signed in Singapore in August 2019, and that's why it is also known as Singapore Convention.
Okay.
And once that all the things are put in place as per that convention, then the compliance or implementation of the cross-border mediations, mediated settlement agreements in commercial matters will also be easier, and maybe the confidence of people will increase in that.
Okay.
Now, the next question is when and how a matter can be referred to mediation. So, a matter can be referred to mediation at any stage. As I said, even before the dispute, means before litigation, as soon as people feel that they have differences or there is a dispute, they can decide to go before a mediator, go to a mediator and get mediation done. If not that, then maybe when they go to advocates to issue legal notice, before legal notice is issued, the advocate can issue a letter requesting to go for mediation. And at that stage, the advocate may refrain from making any allegations in that letter. And it may be stated that because we are suggesting mediation, we are not adverting upon the allegations on merits. And if that doesn't happen, the legal notice does follow, and maybe suit follows. And of course, if the nature of dispute is such that as per law, like commercial, if it is governed by Commercial Courts Act, then parties may have to go for this one, pre-institution mediation. They will have to undergo at that stage. Otherwise, if a suit is filed, then maybe at some stage the court may recommend that why don't you go for mediation, and parties may decide at that stage to go for mediation. Also, in the course of litigation, if one of the parties feels that we should try out mediation, the advocate for that party can request the court or make even application to the court to refer the matter to mediation. Of course, the court will have to ask the other side for consent. If the other side is consenting, then the matter can be referred to mediation. But my experience is that generally when court is asking whether the matter should be referred to mediation or not, generally people give consent because they don't want to have a negative image in front of the court, and so therefore they give their consent and matter is referred to mediation. And otherwise also, even after the passing of the decree, parties can refer the matter to mediation because the compliance can be an issue. Ultimately, you see, it is negotiation. See, a party may be having a decree, but they may also be in quandary as to how to execute this decree. They may not be aware of the assets that the judgment debtor is possessing, and for them the execution of decree may be an issue. And therefore, even at that stage, ultimately, you see, it's negotiation. It's governed by dynamics of problems that each party is facing, or which it is governed by the dynamics of strengths and weaknesses of parties. And so that's why mediation can be resorted to at any stage, and in fact at different stages. In some of the matters, there are 3-4 mediations, but people keep on trying because maybe the situation has changed by then. And then maybe there are quite a few examples that I have come across that parties said that we have undergone 3 mediations. So now what is going to happen? I tell them that, see, every time every mediation is a different mediation. And maybe now the appointed day may have come and it may work out. So why not try it? You are not going to lose anything. So it can be tried at any stage, and even in the course of arbitration, matter can be referred to mediation. And in fact, they call it ARB, MED, ARB. So arbitration, mediation, and again arbitration if mediation doesn't succeed.
Okay.
Or if mediation succeeds, then the arbitrator passes an award on agreed terms.
Okay.
So it's like court annexed mediation. Also, there is a phrase that made are made. That in the course of mediation, suppose parties agree on certain aspects, but some of the issues they are not able to work out. They may agree to refer that issue, those limited issues, to arbitration, get the award of arbitrator, and they then close the mediation with an agreement. With those limited issues, award on those limited issues, that we agreed to that that award will be binding on us.
Okay.
So there is ARB mid ARB and mid ARB mid.
Okay.
That is also there. So it's a concept which is very flexible and people can resort to it at any stage. Now we will look into the role of mediator. Now generally people have a misimpression that a mediator is also like some judge or arbitrator and he is going to decide the matter. But that's not so. The role of a mediator, I always say, is like being a friend, philosopher and guide to both the sides.
Okay.
Friend, philosopher and guide to both the sides, but he has to play that role keeping or maintaining his neutrality without compromising on his impartiality. So he has to help both the sides, but only to an extent and taking care that he doesn't damage the cause of the other side.
Correct.
So maintaining that balance, he has to act as friend, philosopher and guide to both the sides. He is the person who has to do the hand holding of the parties right from their arrival in mediation to reaching an agreement or going out without settling. So his role is the role of a friend, philosopher and guide. He, as I said, he is not acting like a judge. He doesn't have to give a judgment. He doesn't have to look into the merits of the case as far as possible. Only to a limited extent to which he wants to understand the problem of parties, issues between the parties. He looks into the facts. But otherwise, the mediator's focus is on solution. That what can be the solution in this matter. And drive parties also in that direction. And actually it is the duty of the parties also to focus on solution. So focus of all the three has to be on solution. And mediator helps in that. So the mediator just understands the dispute, talks to parties, asks them, generates options for them. That have you considered this? Have you considered this? He doesn't say that you settle like this. He asks them, and quite a few times it happens in the private sessions. That, okay, you say that you have come to court to get this, but have you considered whether, suppose if you are getting this, will it be okay? So that way he has to open up the windows of the minds of parties, which were not open, and show them the other possibilities. Because otherwise, sometimes parties go as if there is only one direction in which they can go, then that is court case. But that's not so. There are other options also, and the mediator opens up those options for them, and then they think over it. Mediator just suggests to them various formulas that can you consider this, and also when proposals come from the other side, the mediator helps each party to weigh the pros and cons of that proposal. That okay, you are looking at this, so now in this proposal these are the advantages and these are the disadvantages for you. Now you decide. Mediator helps them by this analysis or dissection of proposals. But mediator never imposes any decision on parties. Mediator never recommends a particular proposal. Mediator never tells a party that you accept this proposal. And also mediator doesn't negotiate for any party.
Correct.
Although mediation is a process of negotiation. And why does he not do that? Because mediator also talks to parties privately. And in those private meetings, parties open up their mind and heart to mediator. You know, sometimes parties tell mediator, and most of the times, sir, I have filed this suit for 50 lakhs. But I will tell you, frankly, I am willing to work it out if I am getting something around 25 lakhs.
Oh.
I am willing to work out around 30 lakhs. So mediator knows that he is willing to work out at 25 lakhs. Now suppose when he is talking to the other side, and if other side says, ask mediator, do you think I should give an offer for 35 lakhs to work out the matter? Now what does mediator do? Mediator knows that he is willing to work out at 25. Now this fellow is willing to give an offer of 35 lakhs. If he says give, if he says yes, he will do injustice to the person who is giving the offer of 35 lakhs. And if he says no, you can start with a lower figure, then he does injustice to the person who is willing to work out at 25. So, because otherwise he would have got 35 lakhs. So that's why a mediator in principle never imposes any decision, never recommends any decision. Decision has to be taken by the parties, has to be left to the parties. It has not to be influenced by mediator. Mediator has to dissect or analyze the proposals in an objective manner without compromising on his neutrality, impartiality, confidentiality. And even when a mediator talks to parties privately, he has to maintain that confidentiality. The mediator, while talking to party A, whatever information mediator gets, he doesn't disclose that in his meetings with private parties B, when he meets party B privately. So that confidentiality has also to be maintained and not to be disclosed to the judge. And why not to be disclosed to the court? Because at the end of the day, the court has to decide the matter on merits. Only on the basis of evidence that has come before the court and on the basis of the provisions of law. Now suppose if it is all told to the judge as to what happened in mediation, who said what, then judge's mind may get prejudiced or biased. That okay, this fellow was giving a very fair offer, this fellow refused that offer, and therefore this fellow is wrong. And then the judgment that comes may be prejudiced judgment.
Correct.
And therefore there is a Chinese wall between a mediator and a judge, and therefore generally no court is supposed to call mediator and ask as to what happened in mediation. And even if the court asks, the mediator has to be careful not to disclose the discussion. Because it is basic principle, and confidentiality is the strength of this process. Confidentiality gives power to the mediator, otherwise mediator doesn't have any powers. So therefore it has to work like that, and therefore mediator should never negotiate for any party. Mediator should not recommend any particular proposal, selection of any particular proposal. He has to help parties in an objective manner, maintaining his neutrality and impartiality. Okay. So now then we go to appointment of mediator and incidental matters. Now this also we will look at from different types of mediations, that is pre-institution mediation or rather private mediation. In private mediation, both the parties can decide on who should be the mediator they should approach. There is no bar. People can have as many mediators as they want. But generally I feel that there shouldn't be too many mediators, because thereafter you never know who is committing breach of confidentiality.
Correct.
If there are 3 mediators, then unless those mediators are all known to me and I know their reputation, I may be acting very cautiously. Because suppose if one of the mediators also breaches the confidentiality or doesn't follow the procedure appropriately, then the whole process may get vitiated.
Correct.
So, and here there is no question of a majority judgment. So why should people go for many co-mediators?
Correct.
They should find a person who is a reasonably good choice and go to that person. At the highest, they may have one more person. But generally, if both the persons are known to each other, they know their way of working, they can gel well and they can do a good mediation. So, in private mediation, it is up to the parties. So far as pre-institution mediation is concerned under any act, then generally as far as Commercial Courts Act is concerned, the district legal services authority of every state is the administering authority, and they appoint mediators, and through them the parties get mediators. And so far as court annexed mediation is concerned, generally court gives preference to choice of parties. If parties suggest that we want to go to a particular mediator, generally court allows, because basically it is a basic principle of mediation that parties should have a choice. Means forum shopping is allowed in principle so far as mediation is concerned, because see, ultimately arbitrator or mediator, if he is a person whom parties repose their trust in, then it is always better.
Correct.
That things will work out better. But sometimes courts don't accept those choices to ensure that there is fair distribution of work amongst the mediators who are on panel, and therefore they follow roster system, and they give the mediator who is next available as per the roster. But generally, whenever they can accommodate, they accommodate the choice of parties. So far as court annexed mediation is concerned. So these are the three types of mediations in which they are appointed. And also, thereafter, the question of fees of mediator. Fees in private mediation, the parties can decide it in consultation with the mediator, whatever they can negotiate with the mediator, that they can decide and put it in the appointment letter. So far as court annexed mediation is concerned, the court fixes the fees for mediation, and it is for a lump sum amount for the whole of mediation, and it is not per session. So one has to go by that order of the court, and under particular statute, if there is a, say for example under the Commercial Courts Act, there is a schedule of fees given for mediators' fees, and the mediators are paid that fees through legal services, district legal services authority, which is also known as DLSA. Through DLSA, mediators get the payment. So, and of course this civil procedure, ADR and mediation rules also provide for the scale of mediators' fees. So one can take guidance from that also. Now, question is how and where a mediation is conducted. Generally, you see, so far as private mediation is concerned, it can be conducted at a place of choice of both the parties and mediator according to their convenience. So far as court annexed mediation is concerned, or pre-institution mediation is concerned, it is supposed to be conducted in court premises. But if parties wish, they can decide to, by express consent, it can be conducted at any other place where parties agree to get it conducted. And ultimately, if both the parties also give their consent, then there can be online mediation. But so far as online mediation is concerned, I personally feel, out of my experience, that physical mediation is the best mode of mediation. Online mediation, unless there are compelling reasons, like one of the parties being out of India or out of state or out of city, and unnecessary costs may be involved, then there should be online mediation. Otherwise, as far as possible, the mediation should be conducted by physical meetings. So that is there. And also the mediator doesn't have to look into the proceedings. So far as court annexed mediation is concerned, mediator doesn't have to look into the proceedings. Maybe to understand the matter and sometimes to understand certain facts or understand the point of view of a party, the mediator may refer to the copies of pleadings that the parties may show, but otherwise the mediator need not go through the proceedings of the court. The process that has to be followed by a mediator, I have said, it's a flexible process, informal process.
Yes.
And since it's an informal process, the mediator can talk to anyone and everyone in the process. See, if a party wants their relatives also to be heard by the mediator can do it. The only rule that the mediator has to follow is that only those parties will be allowed to sit in the joint session or joint meeting which persons are approved by both the sides.
Okay.
If one of the parties objects that no, this person should not be there, so then in joint session such people should not be allowed to sit. But mediator can privately meet that party and those persons or relatives or whoever friends he is bringing, saying that they can help in sorting out the matter or they want to know what are the things means where do we stand in mediation. They will help me in take a decision. So they can, a mediator can separately talk to everyone, each and everyone.
Okay.
Because see, mediator has to use all possible sources to ensure that parties reach a solution. And so long as the mediator does it impartially, there should be no problem to either party. Okay, so that's it. Now, we have seen the role of mediator. Now we have to look at the role of parties in a mediation. The first and foremost role of parties in a mediation is that they should participate in the mediation process in good faith. They should participate sincerely, and they should not waste their time on arguments with the other side. They should focus on realizing their goals through negotiation. They must remember that it's a negotiation and how to realize their goals in the best possible manner in negotiation. They should make use of mediator to their advantage. They must realize that mediator is here to help us. And so they should take help of mediator. They should take help of their advocates or other advisors and focus on solution, finding a solution, because that is what they have to look for. So this is how they must participate in mediation, and they must prepare themselves to negotiate. They must prepare a negotiation strategy. They must come prepared, and they must work on it sincerely and seriously. This is what is required, expected of parties. Now we come to role of advocates in mediation. Now generally it is felt that ADR means alarming decrease in revenue for advocates. So ADR is interpreted as alarming decrease in revenues by advocates, but that's not so. And advocates have to play a proactive role. Sometimes, advocates feel that what will advocates do? There is not going to be any legal argument. Why should we participate in mediation? But advocates, by their profession, they are trained as negotiators. Day in and day out, they are negotiating in the matter. In fact, when they argue with the court, that is also a negotiation. They are persuading the judge to give order in the favor of their client. So they know negotiation very well as compared to parties.
Correct.
And also, when parties have to take a decision, they have to weigh as to, suppose if I accept this proposal, what am I getting? And if I continue the litigation, what will I get from the court? So who will give an idea, estimate about what the party can get from the court? It is the advocate who can do it, and as I said, they are good at negotiation skills. they can help parties in negotiation by remaining present in the mediation meetings. Then they can interpret the body language and the spoken language of the other side as to what they are aiming for, and accordingly they can negotiate for their party. In the bargaining process, the advocates can help a lot, because they know that, see, they are talking at this level, but it is not the correct level, and therefore we can bring them down. The advocate can have an idea about the levels at which the talk is going on, and they can help in bringing about an equilibrium point, parties to an equilibrium point.
Correct.
So role of advocates is very important, and also in preparing a negotiation strategy also the advocates can help. Parties are not going to understand it unless they are themselves very good negotiators, but such parties are far and few. So but in mediation the advocates also have to remember that they are donning a different hat, and they are here in mediation to find a good negotiated deal for their party, and they are not here to argue with the other side. And to get a good negotiated deal, they must build a rapport with the other side, create an atmosphere of cooperation and cordiality with the other side, so that they can get a good deal for their client. They are here to find a solution to the problem of their client. So their role has to be different, but at the same time they have to protect and guard the interest of their clients. So that is how. Now, some advocates feel that, as I said, alarming decrease in revenue and etc. So they are, but that's a misconception. Actually, in adversarial system, what happens when clients are dissatisfied with the system and they are, not getting the result that they are expecting, or they are not finding a solution, the people are, there is a lot of discontent amongst the clients. And therefore, when they go out, they give a very negative publicity to the system and the advocates. And they, on the contrary, dissuade other clients from going to court. They say that, अरे कुछ होता नहीं है, जाओ मत, मेरा केस 15 साल से पेंडिंग है, 20 साल से पेंडिंग है, कुछ होता नहीं है. या तो someone may say that I got this decree, but it is a paper decree, we are not able to get any compliance to it, we are not getting any money or possession so far. Again, the execution proceedings are going on for last 2 years. So such negative publicity is hurting advocates a lot. Instead of that, if matters are worked out in mediation, same clients will go out and tell others that yes, it can also get worked out. I went to this advocate and he resolved my matter so quickly, within 6 months I found a solution. So that way advocates can use mediation advantageously, and instead of getting a bad publicity,
Scared of ADR.
and instead of being a victim to the bad publicity generated because of the system, they can turn it to their advantage. And in fact, in an interview in 2011, Justice S.B. Sinha of Supreme Court of India had said that it is estimated that only 9% of the disputes are going into the legal system. So that means 91% of the disputes are finding their way to other forums like politicians, underworld, etc., for settling the disputes. And we as advocates, we are seeing the falling rate of filing. The rates are filing rates are going down heavily in various courts. And so that can, if we want to improve it, we need to use mediation to our advantage. And once there is good publicity to the work that advocates do, then their prestige will also increase in the society. Okay, so that should be the role of advocates. Now question is, who can be a mediator? Now see, that way, so far as private mediations are concerned, anyone can be a mediator. The only rider that I would like to put is that that person should be trained as a mediator. He should be a trained mediator. Unless a person is trained as a mediator, I don't think that person can do justice to the role, whosoever that person may be, by and large. See, in 1% matters, if by fluke that person can bring about a settlement, that's a different matter. But otherwise, I believe that any person, howsoever senior enough, or any senior advocate or even a judge, unless that person has undergone training as a mediator, the chances of that person uh, acting positively as a mediator are less, and the chances of success would be affected.
Correct.
So that's why there are certain standards that are laid down, that as per the rules, any advocate having 15 years practice can become a mediator. Any retired judge of Supreme Court, High Court or District Court or any equivalent court can be a mediator. Any expert, say for example engineer, chartered secretary, or someone having particular expertise in a particular field can become a mediator. Even a retired bureaucrat or retired executive can be a mediator. And so far as private mediation is concerned, they can appoint anyone. But these are the categories that are recognized by the rules. So far as court annexed mediation is concerned, 15 years practice advocate or other people having 15 years practice, they can become a mediator. Or even institutions who are recognized as specialists in mediation, specializing in mediation, which are recognized by High Court, they can also become mediators. They can be appointed as mediators. For example, this our Association of Mediation Practitioners, we call it AMP. So that is institution recognized. So one can always recommend, tell the court that this association matter may be referred to this association. Then association allots the matter to one of its members who are trained mediators. So that is how it can work. Now, why mediation is promoted in India by courts? Because see, it is a very simple process, it is inexpensive, and it can restore relationships. It doesn't involve any adverse effects, and it is fast as compared to litigation system. See, by and large, so far as private mediation is concerned, there is no time limit. But so far as court annexed mediations are concerned, as per those ADR rules, the mediation has to be finished within 2 months from the date of first meeting, with a provision that it can be extended by 1 month. So overall, it has to be finished within 90 days. So far as the statutory mediations are concerned, like under the Commercial Courts Act or any other act, then the statute also provides a time period, so that has to be followed. And that's why it's a time-bound process. It is flexible, informal, and also inexpensive. That's why courts feel that it is better that we should refer parties to mediation, and that's why mediation is being promoted by courts in India. Now, future of mediation in India. Now, in Indian courts, it is estimated that there are 5 crore cases pending. There are 19 judges. There is an estimate that there are 19 judges in India per 10 lakhs of population. And there is an estimate that even if no new cases are filed, whatever cases are filed, existing pending cases, if the existing judges deal with only those cases, then also it may take a few decades for them to dispose of those cases. So what is the way out? ADR is the only way out. And within ADR, arbitration is nothing but a mini litigation. It is also expensive, and it involves verdict. So it also gives a verdict, not a solution. And unless there is a solution, and particularly agreed by both the sides, the problem between the parties is not going to end. They will start one or the other litigation. One litigation will end but if they are not satisfied with that, they will start another litigation. So to put an end to all the disputes, and so this is the way out. ADR is the way out, and mediation is the first choice out of ADR options. So that's why courts are promoting it, and we can see that there is a, and also in mediation, existing settlement rate is estimated to be around 40 to 50%.
Oh.
So if that is the settlement rate, why should it not be promoted?
Correct.
And it has other advantages also. Relationships can be restored. The people can save time and cost, all those things. But unfortunately, due to lack of so much awareness, the private mediations in India are not picking up. Because the courts are promoting, the private mediations are not picking up, and only court annexed mediations are very high in India. So even corporates are not resorting to private mediation so much. So only when they realize and there is awareness about mediation, then I think the private mediations will also pick up.
Okay.
Now, so far as the future of mediation in India is concerned, the future speed or pace of progress of mediation in India will depend on, how now recently the Parliament has passed the mediation bill that will soon become the Mediation Act. So with that act in place, the awareness will increase, but it will also depend as to how that act, how effectively that act is being implemented in India. Also, it may also depend on the other legislative provisions that the government may Parliament may introduce. Say, for example, the court can always, the Parliament can always come up with a law that certain types of disputes must be referred to mediation compulsorily. Also, they may come up with a provision. Right now, there is only in Commercial Courts Act there is a provision that the time consumed in mediation has not to be counted while counting the period of limitation. There is no such provision saving limitation in other acts. So if they come up with such provision, also there are no deterrent costs that are being imposed on parties for not attending mediation. So if there are deterrent costs, which are that is a tool being used by courts out in some of the foreign jurisdictions. So if such provision is there, then also mediation will grow at a faster rate. Also, the government and government undertakings should come up with a machinery within themselves to participate in mediation and take appropriate decisions through mediation. Then also it can grow very well. Also, there can be a law which can expand the reach of mediation. For example, under tax laws also mediation can be proposed. In some of the foreign jurisdictions it is there that even in taxation matters, certain types of matters can be referred to mediation. So that can also be another avenue for mediation. So considering all these things and also, you see, all law schools, law colleges in India have started, teaching mediation to the law students, and they have been holding regular mediation competitions. And even the students of Nalsar University, Hyderabad, they got first prize in International Chamber of Commerce ICC mediation competition at Paris in February, I think last February or so. So this competition has been held for 18 years, and in the last 18 years, this is the first time that Indian team has
won the first
got
prize.
the first prize. So you can, and I'm sure these youngsters are going to take up to mediation, and with they will take it to new heights. So, and every Chief Justice of India, after assuming office, he talks about mediation and ADR using it. That's why I see that there is a bright future to mediation in India. So that's how we can look at it. But I would like to end the talk with certain mandatory quotations. Any talk on mediation cannot be complete without stating following quotations, which have assumed a mandatory significance because of the profoundness of their contents. An ounce of mediation is worth a pound of arbitration and a ton of litigation. That is Joseph Greenbaum. Nothing is as powerful as an idea whose time has come. Victor Hugo. Gandhiji has written about a case in his book, My Experiments with Truth. As a lawyer, he had motivated two Indian origin businessmen in South Africa to settle their matter. He has written about his feelings at that time. My joy was boundless. I had learnt the practice of law. I had learnt to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Mahatma Gandhi. Discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees and expenses and waste of time. Abraham Lincoln. So friends, this is mediation. Long live mediation. Thank you.
Parimal sir, thank you very much for the excellent overview of this entire concept of mediation, and a small token from Hammurabi to you.
Thank you very much. Thank you. I hope this is just an introduction to mediation. People will carry it to a greater height after researching on it more and more, practicing it more and more.
Yes, sir.
Thank
Thank you.
Thank you.
Thank you,
Thank you
sir.
for giving this.